Good afternoon, Madam Speaker. I rise to lead the debate of and have read for a second time in this Honorable House the Integrity in Public Life Amendment Bill 2025. I am pleased to report to this Honorable House, Madam Speaker, and to the general public that integrity in public life is now part of the DNA of our society. Good governance is here to stay. Hundreds of senior civil servants, parliamentarians, ministers, board chairs, and other persons in public life have already filed 2 sets of declarations with the Integrity Commission. Our third declarations are due to be filed by April 30th this year. Filing annual declarations of our income, assets, and liabilities is now a part of the lives of all persons in public life at a senior level in our Federation. And it's an assurance to the general public that corruption is no longer the order of the day. Madam Speaker, I am also pleased to inform the general public that 2 new Integrity Commissioners have received their instruments of appointment and will take their oaths of office shortly, given the end of the statutory tenure of the 2 previous commissioners who we commend for their yeoman's service, Mrs. Carol Boddy and Mr. Dennis Knight. I implore the new commissioners, who will be announced after their oath is taken, to hold their oaths dear and always act in the best interests of the people of St. Kitts and Nevis, who are now, after many years of debate, committed by law and action to good governance. Madam Speaker, now, similar question to what was asked by my learned senator colleague to my right. Why are we here today, debating this 2025 amendment? After the 2023 amendment, which brought the Integrity in Public Life Act into full force, I met with the Integrity Commissions for St. Kitts and for Nevis. After those discussions, we made a decision to align the St. Kitts Act and the Nevis Ordinance to eliminate most of the overlapping which occurred, which unnecessarily required some persons in public life in Nevis to file declarations on both islands and at different times. We therefore also decided to align the declaration filing date to April 30th each year, because there was an anomaly, as, for example, the Premier, who is also the leader of the opposition, had to file 2 different declarations with 2 different filing dates at 2 different commissions. Now, if this bill is passed, the Premier and leader of the opposition can prepare 1 declaration and file it with both commissions. His office being one of the remaining persons in public life that must file to both commissions. Also, having experienced 2 years of filings, the Commission also saw some minor adjustments or advancements that needed to be made to make the process stronger. That is why we're here, to clarify some provisions and to provide some additional powers to the St. Kitts Integrity Commission. So I won't be long. Madam Speaker, I'd like to take the people of St. Kitts and Nevis through the short but important amendment. The definition of child in Section 2 has been refined by replacing "of whom the father" with the term "whom the father." More semantics than anything of great substance. The definition of spouse has been clarified by replacing "is married or living" with "is married, comma, or living." Another clarification amendment. In Section 5, in the declarations by public officials, the bill clarifies the requirement for public officials to file declarations reflecting their private interests as at December 31st of the preceding calendar year. There was no clarity in this regard. The intention was you file in April of one year, based on a snapshot of your assets, liabilities, and income as of December 31st the previous year. So in other words, you had 4 months in the new year to be able to gather your accounts and then make your submission. So we've made that extremely and pellucidly clear in the amendment, even though that is what the Integrity Commission had informed all of the persons that were filing their declarations, their 2 declarations before. Also, the Integrity Commission and the Governor General are granted discretion in the amendment to extend filing deadlines for up to 4 months in justified cases. So what we found in the original is that there was inflexibility. And the commissioners felt, because there were persons who had various reasons, who were away getting medical care, away taking care of family members who were getting medical care, were unable to gather their documents and file their declarations, the commission felt that they should have the power to extend in those circumstances. So this amendment does that. Also, it aligns the requirement for the IPL commissioners themselves who have to file declarations with the Governor General. A specific date is put that they must do that as well by April 30th of each year. In Section 6, the Act now requires that bank statements submitted as part of declarations clearly identify the account holder's name, ensuring greater transparency in financial disclosures. That is something they also realize. Persons were submitting their bank statements, but the statements didn't have the name of the person filing on them. So they wish for the statements to be clearer and can be more aligned to the actual person submitting the declaration. In Section 7, there was an error in that Section 5 was referenced, so we're correcting that, so the proper section, Section 6, is referenced. In Section 11, the bill specifies that meetings of the Integrity Commission shall be chaired by the chairperson or, in their absence, the deputy chairperson. So that's just an administrative change. This one is very important, Madam Speaker. The classification of public officials or persons in public life subject to declaration requirements has been revised. After discussions, the Integrity Commission felt that there were some people that were left out because the original list had assistant secretaries, K40 and above. The proposed amendment is that it will be all assistant secretaries and directors at a K40 or above. What this does, because directors have some financial responsibility in respective ministries, the Commission felt it was necessary for those persons to be caught in the net of the Integrity Commission. It's not going to be hundreds of new people. It might be maybe 10 to 20 directors that are caught in this, this new amendment and this new class of persons who are required to file their declarations with the St. Kitts Commission. Importantly, for the Nevis Commission, certain Nevis-based entities, including the Nevis Solid Waste Management Authority, Nevis Tourism Authority, et al., have been removed from the list of entities subject to oversight and now will be monitored by the Nevis Integrity Commission only. Additional public officials have also been added. For example, we did not include the Cabinet Secretary, but the Cabinet Secretary voluntarily filed his declarations, and we're just amending to include that position as well as some other senior positions in the service and in the NIA as well. So there have been several textual modifications that have been made to improve the readability and ensure the consistency in the terminology within the Act. As I said, Madam Speaker, very simple amendment, but very important. You don't get everything right the first time. And it's important to always keep up to date and always advance and make sure that the law is as strong as it can be. And this bill was created after open discussion with the 2 commissions. And we felt that these were the necessary changes and clarifications that needed to be brought to strengthen the Integrity in Public Life Act. So these amendments, Madam Speaker, are what we call a strategic refinement of the existing legislative framework to strengthen the accountability mechanisms for persons in public life. They enhance clarity, consistency, and the effectiveness of the IPL Act, ensuring that it remains a robust tool in promoting transparency and good governance in St. Christopher and Nevis. Madam Speaker, with those few words, I wish the short but important Integrity in Public Life Amendment Bill safe passage. May it please you.
Thank you to the Honorable Attorney General, mover of the bill. I recognize the Honorable Member for St. Christopher 3.
Madam Speaker, with your leave, I rise to second the motion to have this bill read a second time and reserve my right to speak.
I recognize the Honorable Member for Nevis 10.
Thank you very much, Madam Speaker. I'll be very brief. I want to thank the mover of the bill for his presentation, very succinct presentation. And we are thankful as well because I know members of the Nevis Island administration would have asked for these amendments to be made because we thought that persons who were filing on Nevis who were not answerable to the federal government should not have been filing twice. And so we are thankful that this amendment has been made. And so most persons, like from the associations in Nevis, the corporations and so on in Nevis, will not have to file both in St. Kitts and Nevis. One issue of clarity, though, there are members of the Nevis Island administration. I'm assuming that they now still have to file both in St. Kitts and Nevis. I was just wondering why, since they are not hired by the federal government, they're not answerable to the federal government, is there a particular reason why they also have to continue to file on St. Kitts as well as in Nevis? Just that point of asking, Madam Speaker.
Thank you to the Honorable Member for Nevis 10. I recognize the Honorable Member for... I recognize the Honorable Attorney General. My apologies.
Yes, Madam Speaker. I will start by answering the question from the member opposite. In the discussion as to the removal of the corporation, the chairs and so forth, it is true. They are responsible, they are answerable to the Nevis Island administration. But what we felt is the decision makers in the Nevis Parliament, the Nevis Island Assembly, as well as in the Nevis Island administration, could potentially impact the Federation by whatever bills are passed and whatever actions are taken. So the two commissions felt that those persons should still be required to file in both commissions because the impact could be at a federal level. That is what but we made it much easier. You prepare one form, you make a copy, and you drop one off in Nevis and one off in St. Kitts. So it's not as onerous as it was, and I know the members opposite would have recognized that. They have, in the last 2 years, I know they've been filing even before, but in the last 2 years, they've had to prepare 4 different declarations to file. From this year onward, they will just have to prepare 1. And that was the rationale for taking out the board members, the chairs and so forth for Nevis Solid Waste, Nevis Tourism and so forth, but leaving in, for example, the president of the Nevis Island Assembly, the members of the Nevis Island Assembly, because there's still a federal nature in their position. So there was a feeling in the meeting that we had, which had the Nevis commissioners, that they should file to both still. And there are certain powers as well. I think this is an important point, and probably one of the reasons that guided the decision is that there are some extra powers that the St. Kitts Commission have that the Nevis Commission do not have. So they wanted those powers to be able to impact the highest decision makers in both St. Kitts and Nevis. So that was the reason, and I hope that's clarified the question from member opposite. Yes. And Madam Speaker, I do not have much else to add. I can just say that there is a new dynamic in our federation. We are part of the international community that believes in good governance. And I think that taking steps like this and advancing important legislation shows the international community how serious it is, shows potential investors how serious it is, and more importantly, shows the people on whose behalf we act in this House how serious we are about eliminating corruption from our society. May it please you, Madam Speaker.